Louis Sansonito, attorney at law. Where's your office, by the way? Do you actually have a bona fide office?
I do have an office here in the city of Trenton on South Broad Street.
Tell everybody your address.
417 South Broad Street in Trenton.
Now, is your phone shut off or is it working?
No, we have a working operable phone system.
You have a phone number?
Yes, I do.
What's your number?
Of course, area code 609 here in the city, 571-1077.
And of course, anybody who's watching this, he or she can feel free to call you and you'll answer all the questions?
I would love to help them if I could.
You understand that this is a program that we've geared for newly admitted attorneys in New Jersey. I know it's been a long time for you, okay? But I want you to think back to the early days of your practice where you were working for some very cruel taskmasters, right in this building, as a matter of fact. And picture, if you will, you as a brand new attorney and you're handed this probate file to take care of, okay? Would that be a scary proposition for you?
It always would be a scary proposition, no matter what area of law. And probate can be a little bit dicey at times, so obviously you need some help.
It seems to me that there's really kind of three parts to it. Number one, there's will preparation. Number two, after you have an actual decedent who has a will, you've got a number of steps you've got to take initially to get the will probated and to make sure that the desires of the testator have been fulfilled. And number three, you may have trust issues also sometimes that are going to go on for months or years thereafter.
Of course.
So let's kind of talk about this one step at a time. Mm-hmm. In your practice, do you make available to yourself doing wills?
Yes, I do. And I think it's an extremely important type of practice for lawyers to do. And I think it's a thing that lawyers should be doing not only because it's important to the clients themselves, but I think it's important to assist, I believe, justice and assist the courts. I think it's a real crime and a sin many times when I hear of someone dying without a will.
How do you go about advising clients, first of all, about the general issues associated with your drafting of a will? What do you say to them?
Most of the time when people come in, as you said, they usually are coming to you because they finally have gotten beyond this feeling that this will cause my death by doing will, and they really do have some specific provisions they want to put in. Maybe they've recently had a child born, or they see their children getting older, and they're worried what would happen to the children if something would happen to them. Perhaps they're elderly and they're in a situation where they want to make certain provisions for certain people, maybe exclude other people, hopefully for not the wrong reasons. But they come to you with those types of goals in mind, and what you have to do is give them time to vent a bit as to what they want to do, and then sit them down and explain really there's a whole document we're going to prepare here and go through it step by step with them.
What specifically do you say?
I start off as simply as with people, do you intend to be buried or cremated? Many times people will tell me, I hadn't even thought about that. Mm-hmm. And sometimes they need some time to think about it, or sometimes they've already made decisions.
So usually this is going to be a husband and wife situation?
It can be. I don't find it to be exclusively anymore. I think it used to be more husband and wife. Obviously, as we get further and further away from that idea of a family unit being defined as husband and wife, you find less of that.
But what I'm suggesting, though, is it's usually a couple coming to you as opposed to an individual?
Again, it depends really on the situation. Many times it's husband and wife because they want to make some provision maybe for children at that point.
Well, let's talk about the husband and wife situation then initially. Okay. Typically, do you tell them when they come in that they really should have, it's really two wills that should be done initially?
Absolutely. You generally refer to as reciprocal wills, where one will be for the husband, one will for the wife. There may be some provisions that will cross over between them when the first one dies. There may be some specific bequests in the wife's will or the husband's will that are separate and apart from anything in the other's will.
Okay. How about if there's no marital relationship between them? Let's say it's a civil union or they just live together. Mm-hmm. How do you handle those situations?
Again, it can be a similar situation. The term reciprocal will really refers more to the idea that these wills are somehow joined together in their terms and what would happen when the first one dies.
All right. So you would put in the will then as just an initial component how you want the body disposed of.
Right. And perhaps they've already purchased a funeral plot or a mausoleum spot, and they want to make sure that the executor or executrix ultimately know where they want to be placed.
Okay. So, do you think it's a good idea to put down these final directions for deceit in the will, or should there be some type of separate document that covers that?
No, I always put them right into the will. I think it's an important point. I put it right in the first paragraph, where you also give directions about that you want your debts immediately paid for and taken care of.
It's important then that since you're going to need these directions in the will right away, that surviving family members, A, know that there's a will, and B, know where the will can be gotten. It's probably a very bad idea to leave the will around the house. So would you agree as just a matter of common sense that you should be advising your clients to place their will in a safe deposit box?
Yeah, or some safe location. And what I usually tell them, because people say, should I give a copy of this to my executor or executrix? I generally tell people, I don't think that's the best idea, since a will, in my mind, is a living document, is the way I usually describe it.
It's a living document that doesn't speak until death.
Correct. I tell people better probably not to give the actual will, but to tell the executor or executrix where the will is at physically so it can be located quickly. But in the event that you want to make some changes, you don't have this person out there with some belief or a copy of this will which may no longer be valid.
Now, my understanding is that if the will is kept in a safe deposit box inside of a bank, that the executor actually has access and can remove the will and any insurance policies from the safe deposit box. Is that correct?
A bank will grant limited access to remove a will, perhaps a deed to a property, just to get the estate going, but they won't allow initially any material items to be removed from it until that person qualifies.
So this is for tax purposes, though, to make sure everything's accounted for.
Agreed. Years ago, many years in the olden days, actually a representative of the New Jersey Tax Office would have to be present when the box was opened and actually inventory it. Maybe because of budgetary reasons, that type of procedure doesn't work anymore.
But there's no downside in you advising your clients, look, keep one copy of the will, put it in a safe deposit box, make sure the responsible people know where it's going to be, understand that you can go and you'll be able to remove things that are not subject to tax, insurance policies, life insurance policies, and the will.
Correct.
Good advice or bad advice?
Oh, excellent advice.
All right. Now, you've of course the testator will put in the will then the directions about the body.
Correct.
And I would guess if you're doing joint wills, or not joint wills, but two different wills, one for the husband and one for the wife, you're going to have specific bequests, but would you have a section in there in case they're killed in a some kind of common accident?
Yeah. Normally, and again, it's the standard talk I give people. You may have a situation where the husband is a fisherman, right, and the wife could care less about his fishing gear, and he may want in his will to have a specific request, leaving his fishing gear to his fishing friend, his buddy. The woman might say, he doesn't want my jewelry, so when I die, I want that specifically to my girlfriend, Patricia,
right, with
the idea being that when either one of those they die first, that specific bequest will be operational. Then in the body of the will, the rest of it could be just everything else I give, advise, and bequeath to my spouse, and just it would go back and forth.
So the residue and remainder of the estate goes to the spouse, except for these specific bequests.
Right. Then what you would probably have is some sort of provision in the event that my wife, my husband, has predeceased me, and usually this is where the reciprocal nature comes in. I always put in that one will be deemed to have survived or predeceased the other in the event that they would die in a common disaster.
How can you legally do that, though? I mean, is there law that supports that?
Yep, and it just allows one of them to be deemed to have gone first.